Hello. So today we're going to talk about Harris versus Forklift, which is one of the Supreme Court cases that was decided in 1993. So this is about the seventh case into the 10, seventh or eighth, into the 10 that we are evaluating when it comes to how the Supreme Court has interpreted sex related to Title VII and employment law. So let's dig into this, and a few of you would have had this in class, but I wanted to make sure everybody had access to the material about this case. So Harris versus Forklift. Now, a couple of things I want you to think about as we're moving into a discussion about this case are the context of this case. So in 1985, Teresa Harris is hired by the forklift company. And the next year, 1986, is when Vincennes versus Meritor is decided by the Supreme Court. Why that becomes important is because at the time she's hired, the Supreme Court hasn't made any kind of determination related to sexual harassment in the hostile workplace, hostile work environment. So Harris is working there for 2 years. In the middle of that, Meritor is decided. Then after this, after she quits, you have Johnson Controls, which is the last case that we looked at. Now, where this becomes important is that the Johnson Controls case is decided in 1991 by the Supreme Court. Harris is decided by the court in 1993. So again, you've got to slot the cases into the proper sequence to be able to understand exactly how the Supreme Court is building one case on top of the other. So it can be incredibly easy to look at these cases as individualized, happening in their own world, kind of out of context, but to really understand what's happening to Teresa Harris, as well as the action the Supreme Court takes 5 years later, you've got to understand where everything fits related to these other cases. All right, so now let's talk about Teresa. So like a lot of the plaintiffs, she has come straight out of high school and is going into the working environment. So really the only plaintiff that we've had that had a higher education would be Ann Hopkins in the PricewaterhouseCoopers case. For the most part, the rest of them have come straight out of high school. One of the reasons that matters is when you're thinking about the type of job that was available to them and why these jobs were so important to them as they're fighting to make it work or trying to decide whether or not this is an environment they want to continue to work in. So you have to keep those important details in mind. All right, so she's a sales manager. She does a really good job for her company. She doubles their income. But at the same time, her boss, Mr. Hardy, is constantly commenting on the women's clothing, talking about their bodies, making them do completely inappropriate things. And so Harris feels like she is being harassed constantly. Harris, though, was used to working with men, which means she thinks she can handle this at a certain level on her own. Also, in that Nashville, Tennessee area, she had earned a reputation as a savvy businesswoman. So she's not just good at her job, she's recognized as being someone who has some really good skills in this area. So not just personally thinking she's good, but that she actually is quite successful. So she develops chronic insomnia. She gets drunk every night so she can sleep. It creates a strained relationship with her sons. And she's a single parent who's also the main support for her grandmother. Those details are important because it reinforces why she's going to stay in a job that it might be easy to go just leave. She doesn't have a college degree. She's being successful, but she also has the pressure of supporting not only her sons, but her grandmother. So there's a lot of external things happening. How do we know it could be, the work environment could be impacting her? It's the physical effects, and this is going to become important in the case. So Forklift Systems, the way I described it in class is that it's a company that is leasing or selling like Caterpillar machines. So it'd be like a dealership for those small construction type of machines. And then when Harris gets married, her new husband ends up having a very major contract with Harris, which only adds to the stress of her needing to keep this job. So she calls a meeting in August of 1987 to quit. Hardy talks her out of it, and then in October, she does quit. And then her fears are confirmed when her husband's contract is canceled, and the loan that he has with Hardy is called. So what happens? She's mad, she's hurt, she's frustrated, and then the worst case scenario happens where her husband loses that major contract and his loan is called as well, so the financial stress just multiplies. So what does she do? She sues. So she ends up going to district court, where the judge there says it's a close case. However, he's struggling to define what an abusive environment is. So the court says that she was insulted, but that the comments did not create an abusive environment. And one of the reasons is the Supreme Court had, in an earlier case, identified this severe versus pervasive scale. So the way to think of this is, when you're looking at a hostile work environment, what the courts, kind of the test they're going to use, is how severe are these actions? And based on how severe they are, then how pervasive are they? How many of these events or incidences are happening? So the more severe the abuse is, the less frequent or pervasive they have to be. The less severe it is, then the more pervasive, the more often there need to be these hostile environment types of things happening. So when the district court is evaluating the environment that Harris has been asked to endure, that particular judge says, well, the severity is not so bad. It's not as bad as Meritor. And it's pervasive, but because the severity is so low, the frequency isn't often enough to counterbalance. And so it says it's a close call, but we're not going to find that it's an actionable instance. Then the Court of Appeals for the Sixth Circuit affirms. It reaches the same conclusion as the district court. So they proceed to the Supreme Court, where O'Connor writes for a unanimous court. Scalia and Ginsburg filed concurrences, but they decide that the issue really is, what is a discriminatorily abusive work environment? Or in the language that we use, what's a hostile work environment? So the important thing that the court decides in this case is that you don't have to suffer this massive injury. It doesn't have to leave you in a place where you're suffering from post-traumatic stress disorder, you're chronically depressive, or any of those types of serious psychological issues. Instead, the court's kind of lowering the standard that was set in Meritor and said, we need to evaluate this on a way that's going to provide protection to employees before they're pushed to the point where they now have a psychological diagnosis. And so that's basically what the court is deciding in this situation. And what it does is it affirms the language that they adopted in Meritor of that severe and pervasive language, but says it doesn't have to be all-out psychological harm. So Title VII can come into play before the harassing conduct leads to a nervous breakdown. So normally I wouldn't read this to you, but because we're on video, Title VII is violated when the workplace is permeated with discriminatory behavior that is sufficiently severe or pervasive to create a discriminatorily hostile or abusive working environment. And it requires an objectively hostile or abusive environment, or a reasonable standard of what is hostile or abusive. This is the other thing that the court is adding to the conversation with this case, with Harris's case. They're saying now that one of the challenges with hostile work environment is that it is so subjective. What I would consider sexual harassment or workplace bullying or anything like that is going to be very different from what you would. Our experiences are different. Our thresholds for what we'll tolerate, what we'll try to handle on our own is different. And so what the court is doing is they're saying, okay, we can't remove all the subjectivity from this, but what we're going to do is we're going to say, what would a reasonable person who's outside that work environment and they're looking in, what would they say? Would they go, oh my gosh, this is a hostile environment and it's not okay? If an objective person would, someone who's not in the middle of the situation, then that's going to be a hostile work environment. So it's the court's attempt to kind of step outside of the immediacy of the problem and evaluate how would normal, reasonable, and it's squishy, it just is, but it's now moving outside of the 2 or 3 people who are involved in the situation and saying, now this is how we're going to determine whether or not it's harassment. So they're going to ask questions like, is the environment hostile or abusive? They're going to look at the frequency of the conduct, the severity, so there again, it's pervasive and severe, whether it's physically threatening or humiliating or a mere offensive utterance, so the difference between actions and words, and whether it unreasonably interferes with an employee's work performance. So they're kind of expanding that definition of pervasive and severe. And then now we can look at the psychological harm. So one of the things I said in class was make sure if you're in a situation where you feel like you're being placed in a hostile work environment and it's beginning to affect you, go see a counselor. It's going to help an attorney if you reach that point to have some kind of, again, objective outside perspective that says, yes, this person was harmed. Here are the clinical things that have happened to them. And so you don't have to have just you've lost your job. It can be psychological, and that's seen as a valid harm now. So no single factor is required. We're going to look at kind of the whole totality of the circumstances. Scalia says, I agree with the court, so I'm joining the unanimous opinion. However, I wish this wasn't so squishy. And the challenge is that's the way it has to be in this situation. There's no way to strictly define because every individual is so different. So what Scalia is saying in his concurrence is, this is squishy, and I can't see a way around it. If he could have, he would have written a blistering dissent saying why what the majority was doing wasn't effective. And instead he's saying, I may not be totally comfortable with it, but this is the only way we can approach this. So that's the purpose of his concurrence. And then Ginsburg's concurrence basically is the same. So they're both concerned that it's squishy, but that's just how it is. And then I thought you would like to know, and this link will take you there, that the case was ultimately settled, as often happens when it bumps back down to the lower court. And she did receive a settlement from the court, but that's Harris versus Forklift Systems. And that gives you kind of the context for what was happening and what was going on. And if you have any questions, I'll have a discussion board where you can post them there. But hopefully that helps you kind of understand how this case fits into the sequence of all the others.